Friends, today we are here to discuss the cultural and educational rights under the Constitution of India. To start with, Articles 29 and 30 of the Constitution of India guarantee cultural and educational right to certain religious and linguistic minorities. Under Article 29, Clause 1, any section of the citizens residing in any part of the territories of India having a distinct language, script and culture of their own shall have the right to conserve the same. And under Article 29, Clause 2, the state is debarred from denying to any citizen admission to any educational institution maintained by the state or receiving aid out of the state funds on the ground only of religion, race, caste, language, or any of them. Article 30 makes provision for the right of minorities to establish and administer educational institutions of their choice. Article 30, Clause 1 gives right to the linguistic and religious minorities the right to establish educational institutions and the right to administer educational institutions so established by them. Article 30, Clause 2 bars the state, while granting aid to educational institutions, from discriminating against any educational institution on the ground that it is under the management of a linguistic or religious minorities. Any section of Indian citizens, whether minority or majority, if they reside in any part of the territories of India, has the right to, if they have any distinct language, culture and script, to conserve the same. The constitutional provision in Article 29 protects the language, script and culture of a section of the citizens. The implication of Article 29 was explained by the Supreme Court of India in D.A.V. College, Jalandhar versus Union of India, which is reported in AIR 1971, Supreme Court 1737. The question before the court was whether a legal provision requiring the Guru Nanak University to promote studies and research in Punjabi language and literature and to undertake measures for the development of Punjabi language and literature infringe the provision of Article 29, Clause 1 or not. The Clause 2 of Article 29 is broad and unqualified. Under the article, the benefit is not confined to only minority groups, but it extends to all citizens in the matter of admission to educational institutions maintained by or aided by the state. The question for application of Article 29, Clause 2 arose for the first time in the case Madras versus Champaka, which is reported in AIR 1951, Supreme Court, page number 226. In this case, the government of Madras issued an order that seats were allotted in the medical and engineering colleges in the state proportionately to the several communities, that is non-Brahmin, Hindus, backward Hindus, Harijans, Anglo-Indian, Christians and Muslims. After the judgment in Champakam, the constitution was amended and clause 4 in Article 15 was inserted. The provision in Article 15 clause 4 is an enabling provision and has been made to empower the state for making advancement of any socially and educationally backward classes of the Indian citizens or for scheduled tribes and scheduled castes. Therefore, as regards Article 29 clause 2, it should be read subject to Article 15 clause 4, which permits special provisions for backward classes. Clause 1 of the Article 30 reads as, all minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Under clause 2 of Article 30, the state shall not, in granting to educational institutions, discriminate against any institution on the ground that it is under the management of a minority, whether based on religion or language. Article 30 makes provision for the linguistic or religious minorities. The Constitution uses the term minority without defining it. In a case reported as in the Kerala Education Bill, reported in AIR 1958, Supreme Court, page number 956. The Supreme Court of India has confronted with the problem and found out that it was a complex situation to give an easy definition of the term. It has stated that it is easy to say that minority means a community which is numerically less than 50%. But the important question is 50% of what? That is, of the entire population of India, or a state, or a part thereof. Because a community may be a majority in a state, but a minority in the whole of India. Therefore, minority would mean the minority which is determined only in relation to the particular legislation which is being challenged. The linguistic and religious minorities are given the privilege to establish and administer educational institutions of their own choice. The words establish and administer is to read together, meaning thereby that a minority can claim a right to administer an educational institution only when it has been established by it and not otherwise. The rights of minority to establish and administer educational institution carries with it the right of the minorities to impart the instruction to its children in its own language. A reading of Article 29, Clause 1 and 30, Clause 1 together is that the minority institution has the choice of medium of instruction. A rule prohibiting the minority institution from using a particular medium of instruction of its own choice constitutes a violation of the right to administer its own choice. Thus, a rule made by the Gujarat University prescribing Gujarati or Hindi as the sole medium of instruction and examination in the college affiliated to it was held to infringe the right of the Anglo-Indians whose mother tongue was English. One important aspect for administration of educational institution in a minority institution is about the maintenance of discipline among the staff. The final power to take disciplinary action must vest in the administration of the institution without being subjected to any outside control. In a case, St. Xavier's, which was reported in AIR 1974, Supreme Court 1389, a provision making penalty imposed on a member of the staff of a college subject to Vice Chancellor's approval has been held to infringe Article 30, Clause 1 on the ground that a blanket power without any guidance has been conferred on the Vice Chancellor, and thus the right of the management to take disciplinary action against the staff has been taken away. The situation that could be seen is that institutions of general education established and administered by religious or linguistic minorities enjoy a much more privileged position than those run by majority in the matters of regulation by the government or the university. While strict provision can be imposed on the majority institution, the same cannot be done as regards minority institution, and the affairs of such institutions can be regulated only with a very narrow limit. Every university will now have to maintain two sets of regulations, that is, one for the majority and other for the minority colleges. And further, in the case of minority institutions, there can only be these regulatory provisions. This is well illustrated in a case Lily Kurian versus St. Louisa, reported in AIR 1979, Supreme Court 52. Further, the right to establish educational institutions of their choice has come to mean right to administer this institution free from external interference and in the way as they like. Further and more interpretations are awaited from the courts in future. In order to invoke Article 29, Clause 1, all that is essential is that there must be a section of citizens who reside in any part of India, who have a distinct culture, language and script, and such section of citizens should have the right to conserve the same. This constitutional provision, therefore, protects the language, script and culture of the section of the citizens. The idea behind is that the state shall not impose upon it any culture other than the community's own culture. Such community shall have the right to establish and administer educational institutions of their choice. And the state shall not, in granting aid to educational institutions, discriminate against such an educational institution maintained by a minority community on the ground that it is under the management of a religious community. Further, by virtue of Article 30, Clause 1a, full compensation has to be paid if the state seeks to acquire the property of a minority educational institution. The preamble to our Constitution aims at securing unity and integrity of the nation. Religious and cultural safeguards have been granted by the Constitution to minority communities in order to ensure them justice, social, economic and political, liberty of the thought expression, belief, faith and worship,